Understanding Rule 19 and the 2026 SEBI amendments. Public offerings, IPOs, and listing explained. Hello everyone, welcome back to the channel. Today, we are going to dive into the latest Securities Contracts Regulation Amendment Rules 2026 analysis and impact on listed companies and investors. Before we get into the details of the amendments, it's important to understand the foundation. Rule 19 of the Securities Contracts Regulation Rules 1957 and why it matters for companies, investors, and the stock market. You will learn from today's topic. 1. What Rule 19 is and when it applies. 2. What are the amendments made with Securities Contracts Regulation Amendment Rules 2026? 3. Comparison. Old versus new provisions. Rule 19B. 4. Key changes brought by the 2026 amendment. 5. How public shareholding is determined based on company size. Summary. Whether you're a student, investor, or professional, this video will make complex SEBI rules simple and practical. Absolutely. Let's break it down clearly and practically. 1. What Rule 19 is? Rule 19 is all about minimum public shareholding. Essentially, it specifies how much of a company's shares or convertible debentures must be offered to the public when the company goes for an IPO or lists its shares on a stock exchange. Key points. 1. Purpose. Ensure minimum public shareholding (MPS) in companies listed on stock exchanges. Protect minority shareholders from excessive promoter control. Improve market liquidity and transparency. 2. Scope. Applies to all companies seeking to list securities on a recognized stock exchange in India. Covers equity shares and debentures convertible into equity shares. Defines how much must be offered to the public depending on the company's post-issue capital. 3. Reference. Rule 19 is framed under the Securities Contracts Regulation Act 1956, which empowers the government to regulate stock exchanges and contracts in securities. Rule 19 applies in practical situations related to public issues and listings. A. Initial public offering (IPO). When a private company wants to go public, Rule 19 dictates the minimum percentage of shares that must be offered to the public. Example: a company with post-issue capital less to equal to 1,600 crore rupees must offer at least 25% of shares to the public. B. Follow-on public offers (FPO). For companies already listed, issuing more shares to raise capital, minimum public allotment rules still apply. C. Companies with large capital. Rule 19 specifies different thresholds for medium, large, and ultra-mega companies. Post-issue capital ranges from 1,600 crore to 5 lakh crore rupees or more. Provides phased timelines to increase public shareholding to 25%, ensuring gradual compliance. D. Companies with superior voting rights. If a company issues shares with superior voting rights to promoters or founders, Rule 19 mandates listing ordinary shares for public alongside voting shares, protecting minority investors. E. International Financial Services Center (IFSC) listings. Rule 19 also applies to companies listing in IFSCs but with modified thresholds. For example, 10% public offer instead of 25%. 3. Why it's practically important. Investor protection. Ensures promoters do not dominate immediately after listing. Liquidity. Guarantees enough publicly held shares for trading. Compliance roadmap. Phased increase timelines reduce sudden shocks to stock markets. Regulatory enforcement. Exchanges can impose fines for non-compliance. Practical example scenario. A company with post-issue capital 3,500 crore rupees wants to list. Rule 19 requires offer shares worth 400 crore rupees to the public. Minimum allotment. 2026 amendment must gradually increase public shareholding to 25% within 3 years. Impact. Investors know more shares will gradually become tradable, improves liquidity and transparency. In short, Rule 19 is the foundation of public participation rules in India's stock markets, and it applies whenever a company offers equity or convertible debentures to the public, whether in IPOs, FPOs, or certain special cases like dual class shares or IFSC listings. Changed as compared to previous provision. I have highlighted the changes in the 2026 amendment compared to the old provision. I will bold the new/added provisions and indicate what is unchanged from the old rule. I'll focus on subclauses 1 to 8 for clarity. What are the amendments made with Securities Contracts Regulation Amendment Rules 2026? Comparison. Old versus new provisions. Rule 19B. Clause 1. Small companies let them put 1,600 crore rupees. Old provision. At least 25% of each class or kind of equity shares or debenture convertible into equity shares issued by the company if the post-issue capital of the company calculated at offer price is less than or equal to 1,600 crore rupees. New provision 2026 amendment unchanged. Same 25% requirement for companies let them put 1,600 crore. Clause 2. Medium companies 1,600 crore and let them put 4,000 crore rupees. Old provision. At least such percentage of each class or kind of equity shares or debentures convertible into equity shares issued by the company equivalent to the value of 400 crore rupees if the post-issue capital of the company calculated at offer price is more than 1,600 crore rupees but less than or equal to 4,000 crore rupees. New provision 2026 amendment at least such percentage equivalent to 400 crore same as old plus provided that the company referred to in subclause 2 shall increase its public shareholding to at least 25% within a period of 3 years. Change. Phased compliance to 25% over 3 years added. Clause 3. Large companies 4,000 crores and Leicester here to 50,000 crores. Old provision. At least 10% of each class or kind of equity shares or debentures convertible into equity shares issued by the company if the post-issue capital of the company calculated at offer price is above 4,000 crore but less than or equal to 1 lakh crore. New provision. At least 10% if post-issue capital 4,000 crore rupees but Leicester here to 50,000 crore rupees. Plus increase to 25% in 3 years. Change. Upper limit revised was 1 lakh crore rupees, now 50,000 crore rupees. Phase 25% compliance added. Clause 4. Very large companies 50,000 crore rupees and Leicester here to 1 lakh crore rupees. Old provision. Equivalent to value of 1,000 crore and at least 8% if post-issue capital above 50,000 crore rupees, but Leicester here to 1 lakh crore. Increase to 25% within 5 years. New provision. Unchanged. Same 1,000 crore plus 8% rule. 25% within 5 years. Clause V. Mega companies 1 lakh crore rupees and Leicester here to 5 lakh crore. Old provision equivalent to 6,250 crore and at least 2.75%. Increased to 25% phased over 5 to 10 years. New provision unchanged, same value plus percentage, phased 15%, 25% compliance. Clause 6. Ultra mega companies 5 lakh crore rupees. New provision added. Equivalent to 15,000 crore and at least 1% if public holding 15% at listing, increased to 15% in 5 years and 25% in 10 years. If public holding greater than equal to 15%, increase to 25% in 5 years. Change. Completely new clause. Did not exist in old rule. Clause 7. Minimum offer despite Clause 6. New provision added in 2026. Notwithstanding anything in subclause 6, at least 2.5% of each class must be offered to the public. Applicable to companies listed before 2026 amendment. Clause 8. Stock exchange penalty for past non-compliance. New provision added in 2026. Recognized stock exchange may impose fine or penalty against companies for non-compliance committed before the 2026 amendment. Other additions in 2026 amendment. 1. IFSC International Financial Service Center Companies. Clause I. 25% to 10% for IFSC listing. Subclauses 2 to 7 do not apply. 2. Mandatory listing of superior voting shares along with ordinary shares, also clarified in subclause 7 equivalent. Summary table: old versus new subclause. Old provision, new provision or change. 1. 25% for letter equal to 1600 rupees. Unchanged. 2. Value of 400 rupees for 1600 to 4000 rupees. Same value plus phased increase to 25% in 3 years. 3. 10% for 4000 to 100,000 crore. Upper limit reduced to 50,000 crore. Phased 25% compliance added. 4. 1000 crore plus 8% for 50,000 to 100,000 crore. Unchanged. V. 6,250 crore plus 2.75% for 100,000 to 500,000 crore. Unchanged. 15 to 25% phased compliance clarified. 1. Numberane. New. 15,000 crore plus 1% phased 15 to 25% or 25% in 5 years. 7. Numberane. New. Minimum 2.5% for all companies. Timelines for pre-2026 listings. 8. Numberane. New. Stock exchange can impose penalty for pre-2026 non-compliance. Subclause. Old provision, new provision. 2026 amendment. Key change. Reason depicted in the table. 25% minimum public offer if post-issue capital leather equal to 1,600 crore rupees. Unchanged. No change needed. Small companies continue to maintain 25% public holding. Minimum percent equivalent to 400 crore rupees for 1600 to 4000 crore. Same 400 crore rupees plus must increase public shareholding to 25% within 3 years. Added phased compliance to ensure gradual increase in public float. 10% for 4,000 to 100,000 crore, 10% for 4,000 to 50,000 crore, plus must increase to 25% in 3 years. Upper limit reduced, phased compliance added. Helps large companies improve liquidity. 1000 crore rupees plus 8% for 50,000 to 100,000 crore. Same, 25% increase within 5 years. Compliance timeline clarified. 6,250 crore rupees plus 2.75% for 100,000 to 500,000 crore. Same, phased increase 15 to 25% over 5 to 10 years. Adds clarity on gradual public shareholding for mega cap companies. Number A, 15,000 crore rupees plus 1% for 5 lakh crore, phased increase 15 to 25% or 25% if greater bull if 15% at listing. New clause to cover ultra mega companies previously unregulated. Number A, at least 2.5% must be offered to public even if clause 6 applies, includes pre-2026 listings. New safeguard to ensure minimum public participation. Number A, stock exchange may impose fines for pre-2026 non-compliance. New enforcement tool for past defaulters. Why public shareholding matters. Public shareholding is the percentage of shares held by investors other than promoters or founders. It matters because market liquidity. More shares in public hands, easier trading. Transparency. Wider shareholding reduces manipulation risk. Investor confidence. Ensures everyone has access to the company's growth. Now let's see how company size determines public shareholding under the 2026 amendments. 3. Public shareholding based on company size 2026 amendment. The 2026 amendment introduces tiered thresholds based on post-issue capital. Here's a simplified table. Company size, post-issue capital, minimum public offer timeline to reach 25% public shareholding, letter vehicle 1,600 crore rupees, 25% of shares. Immediate 1,601 rupees minus 4,000 crore rupees. 400 crore rupees worth of shares, 3 years. 4,001 rupees minus 50,000 crore rupees. 10% of shares, 3 years. 50,001 rupees minus 1 lakh crore rupees. 1,000 crore rupees plus 8% of shares, 5 years. 1 lakh 1 rupees minus 5 lakh crore rupees. 6,250 crore rupees plus 2.75% of shares, 5 to 10 years. Lakh crore 15,000 crore plus 1% of shares, 10 years. Let's go through examples to make this crystal clear. Practical examples. Public shareholding 2026 amendment. 1. Small company, leader 1,600 crore rupees. Example, a startup plans IPO with post-issue capital equal to 1,200 crore rupees. Rule, must offer 25% shares to public. Calculation, 25% of 1,200 crore rupees equal to 300 crore rupees shares to public. Timeline, immediate at IPO itself, meaning no relaxation, full compliance from day 1. 2. Medium company 1,601 minus 4,000 crore rupees. Example, company size equal to 3,500 crore rupees. Rule, must offer 400 crore rupee worth shares. Calculation, 400 crore divided by 3,500 crore rupees, approximately 11.4% initially. Timeline, must reach 25% within 3 years, meaning lower burden at IPO, gradual increase later. New 2026 change. 3. Large company 4001 minus 50,000 crore rupees. Example, company size equal to 20,000 crore rupees. Rule, offer 10% shares. Calculation, 10% of 20,000 crore rupees equal to 2,000 crore rupees. Timeline, reach 25% in 3 years. Meaning, strategic planning required. Big companies get flexibility but must increase liquidity over time. 4. Very large company 50,001 minus 1 lakh crore rupees. Example, company size equal to 80,000 crore rupees. Rule, offer 1,000 crore rupee plus minimum 8%. Calculation, 8% of 80,000 crore rupees equal to 6,400 crore rupees. So higher of 1,000 crore rupee or 6,400 crore rupees. 6,400 crore rupees. Timeline, reach 25% in 5 years. Meaning, ensure substantial public participation. More time given due to size. 5. Mega company 1 lakh 8 pi lakh crore rupees. Example, company size equal to 2 lakh crore rupees. Rule, offer 6,250 crore rupees plus 2.75%. Calculation, 2.75% of 2 lakh crore rupees equal to 5,500 rupees. Compare 6,250 crore rupees versus 5,500 crore. 6,250 crore rupees applies. Timeline, reach 25% in 5 to 10 years, meaning very large companies get longer phased compliance. 6. Ultra mega company 5 lakh crore rupees. Example, company size equal to 6 lakh crore rupees. Rule, offer 15,000 crore rupees plus 1%. Calculation, 1% of 6 lakh crore rupees equal to 6,000 crore. Compare 15,000 crore rupees versus 6,000 crore. 15,000 crore rupees applies. Timeline, case 1. If public holding 15%, 15% in 5 years, 25% in 10 years. Case 2. If greater par 15%, 25% in 5 years. Meaning, brand new rule 2026 designed for giant companies like Reliance type scale. छोटी कंपनीज को तुरंत 25% देना पड़ता है, जबकि बड़ी कंपनीज को फेस टाइमलाइन दिया गया है 3 साल, 5 साल या 10 साल तक. With this, we come to the end of today's discussion. I'd love to hear your perspective. Do you think this amendment will act as a catalyst for larger IPOs in India, or will it primarily benefit already established players? Stay connected for more in-depth insights on the Companies Act, securities laws, and key regulatory developments. Make sure you're subscribed. And if you have any thoughts, questions, or differing views, drop them in the comments below. Let's discuss.
Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The Speaker, the Institute of Company Secretaries of India, and any organization or listed company with which the Speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The Speaker confirms that no unpublished price-sensitive information, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only, and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI, Prohibition of Insider Trading Regulations, 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.